Okay, check this out. We have this 18-year-old male who sleeps with this 26-year-old woman. They have a great time, but his mom gets upset and calls the police. The 26-year-old is arrested and is facing multiple felony charges, not because he was underage, because she was his teacher.
Elisa, thank you. Breaking news right now at 6 o'clock. These new details in the arrest of a Charlotte-Mecklenburg high school teacher accused of having sex with an 18-year-old student.
And prosecutors say the boy's mother allegedly caught them in the act.
Now, this is Gabrielle Neufeld, a 26-year-old biology teacher who was accused of engaging in sexual intercourse with her student who happens to be 18 years old. Now, these sexual encounters all happened after October 18th, 2023, and there were at least 5 encounters.
Court documents say Neufeld, who is a science teacher at the school, and a student engaged in activities at least 5 different times since October 18th. These allegedly happened at an off-campus address.
Now, the alleged incidents all occurred in Charlotte, North Carolina. Now, the weird part about this story is that the mom of the 18-year-old actually found the teacher and her son having consensual sex in a parked car. When she observed the teacher and the son getting it on, she called police, and this is what happened.
Gabriella Neufeld is facing 5 felony counts of sexual activity with a student. According to prosecutors, the student's mother found out about the relationship around Thanksgiving. They say she was tracking her son's location when she noticed he was not at rugby practice on Wednesday. She drove to his location, Park Road Park in South Charlotte. Prosecutors say that's when she saw her son and his teacher having sex in a car and called police.
Is there anything you want to say about the allegations against you? This is just your opportunity if you want to say anything.
So the teacher here was arrested and booked on all 5 felony counts. But the big issue here is, why was the teacher charged? They are both consenting adults. The alleged victim here is 18 and the teacher is 26. But the law in North Carolina thinks differently. See, they have adult statutory assault crimes.
In North Carolina, it is illegal for a teacher or any school personnel to have a sexual relationship with any student if that teacher is 4 years older than the victim, which in this case she was. It makes no difference whether the sexual activity was consensual or not. And according to the law, in cases like this, teachers, administrators, or coaches can be charged with a felony.
So when you look up the law, it's pretty crazy. You could have a 25-year-old sleep with a 30-year-old, and under this law, that would be a felony sex crime. Here's a justification for that law.
The student is in a position of vulnerability to the teacher, a position of trust for them. So you don't want to have a teacher who can manipulate a person's consent, just like a doctor, attorney, therapist. When you have that relationship of trust and vulnerability, it poses a bigger risk to the victim.
Now, the teacher is facing a maximum of 47 months in prison because of this adult statutory assault law. Now, there could be challenges to this law, obviously. For instance, does the government even have the authority under the U.S. Constitution to make it a crime for 2 consenting adults to have sex? What about freedom of association? See, the counter argument is that the government already limits consenting adults from having sexual activities in certain circumstances. For instance, adult prisoners who are locked behind bars can't consent to sex with prison guards. This is because of the overwhelming power dynamic between the two. But now, can the state apply this same reasoning to the student-teacher relationship? Is the relationship between teacher and student similar enough to the relationship between prisoner and prison guard to make consent for a student impossible, even if they're an adult? Now, the interesting part about this is the constitutional question here is going to be, how far can the government go? Remember, this also says that the younger student who is an adult cannot consent to having sex with their teacher. Do they have the right to be able to have sex with whoever they want? Now, this teacher should lose her job, but criminal prosecution seems a little overkill. Remember, even if the student was 21, the teacher would still be breaking the law because she's 26, more than 4 years his senior. So, question, If you were on the Supreme Court, how would you rule? Would you rule that the law was a constitutional exercise of the police powers of the state? Or would you say it was unconstitutional for the state to take away a competent adult's ability to consent to sexual intercourse with the partner of their choosing? Now, there is a Supreme Court case that I think may help your decision. It's called Lawrence v. Texas. In this case, two men were having consensual sex when they were arrested by police because the law in the state of Texas made it illegal for same-sex couples to have sexual intercourse. Now, in this case, the Supreme Court came down on the side of the two men, saying that they had a constitutional right to have sex with whoever they wanted, with some exceptions. Now, here is Justice Kennedy writing for the Supreme Court, and he's going to tell you what those exceptions are and what the exact holding of the case is.
The present case does not involve minors. It does not involve persons who might be injured or coerced, or who are situated in relationships where consent might not easily be refused. It does not involve public conduct or prostitution. It does not involve whether the government must give formal recognition to any relationship that homosexual persons seek to enter. The case does involve two adults who, with full and mutual consent from each other, engaged in sexual practices common to a homosexual lifestyle. The petitioners are entitled to respect for their private lives. The state cannot demean their existence or control their destiny by making their private sexual conduct a crime. Their right to liberty, under the Due Process Clause, gives them the full right to engage in their conduct without intervention of the government. It is the promise of the Constitution that there is a realm of personal liberty which the government may not enter. Had those who drew and ratified the Due Process Clauses of the Fifth Amendment or the 14th Amendment known the components of liberty in its manifold possibilities, they might have been more specific. They did not presume to have this insight. They knew times can blind us to certain truths, and later generations can see that laws once thought necessary and proper, in fact, serve only to oppress. As the Constitution endures, persons in every generation can invoke its principles in their own search for greater freedom. The judgment of the Court of Appeals for the Texas 14th District is reversed.
So now, at the end of the day, how would you rule? Do you believe this teacher and student were exercising their constitutional right to liberty to have sexual intercourse with the adult that they choose to have it with, even though they had this relationship? Or do you think the state has the more compelling argument that this is more similar to a prisoner and prison guard, where the student's ability to consent is so colored by the relationship itself that essentially the adult student cannot give consent? Let me know in the comment section. My name is Nate the Lawyer, and I'll see you next time. Peace.